Well, I would just like to thank both Mark and Louise very much for inviting me to give this seminar, and thank you all for coming along to hear about it. So I want to talk to you about this research project that I've been involved in while I've been visiting here at Cambridge. It was a project that arose last year when I spoke at a conference in New Zealand that was organised by Cornell Law School and Victoria University in Wellington. And the conference had the very ambitious goal of examining, and here it is, legal personality as a tool to benefit society, future generations and humanity. It was big, and it wasn't only about corporations. It was about, how do we give legal rights, legal personality to rivers in New Zealand, which they have done. So it was quite wide-ranging. Now, the project that I've gone on to write up, because it's going into a book to honour one of the people that set up that conference, Professor Lynn Stout, who sadly died earlier this year, and so this book is in her honour. And I'm not looking at how to benefit humanity with corporations. I'm just looking at how to minimise the damage they do to, the world. And so my project is to look at liability for when corporate cultures go wrong and when they harm stakeholders or when they harm society. And also to look at how to ensure that there is accountability if and when that occurs. So this phrase, corporate culture, it's been basically said, now hang on, but yeah, there we go, to be a slippery concept. And Dan Orey and some co-authors of his, David Kershaw, who spoke here only last week, they said this is a slippery concept. And I actually had coffee in London yesterday with Dave Kershaw, and he said, at the end of writing our piece, we just decided we should trash the whole idea of corporate culture, never mention it again. It is just, hopeless. But, they may have thought that, but look at all the people who are talking about it. Europe, America, and these three in the middle, these are all UK. This discussion paper from 2016 about corporate culture and the role of boards has now been rolled into the 2018 UK Corporate Governance Code, and the British Academy project, The Future of the Corporation, has got corporate culture front and centre. Now, not only that in the UK, but in my own jurisdiction, it's come to the forefront in these banking inquiries, which you may or may not be aware of. This one, the Australian Banking Royal Commission, is going on at the moment. They just brought out their interim report in September, and they have identified all sorts of cultural problems in the Australian banks, which is surprising because post-global financial crisis, the Australian banking world was seen as, the great beacon of banks doing well and behaving well. Well, that is no longer. They're now under the blowtorch in Australia. Also, in Australia, we've had corporate governance principles similar to the ones in the UK since 2003, and there's a very controversial fourth edition coming out, and it's controversial because it has things in the fourth edition such as this reference to the fact that corporations have a social licence to operate. Now, that's very different to the way we have thought of corporations since the 1980s. The dominant paradigm of the law and economics paradigm is very much that corporations are private bodies. And so this idea of saying, well, they have a social licence to operate, some of the Australian business world think that that's turning things back to the 19th century, where we had the old franchise theory of the corporation, that they were only allowed to operate because the government said they could. So here are, all the regulatory bodies that are saying corporate culture matters. They're saying it matters for a variety of different reasons. They're saying that, healthy corporate cultures are important because they're part of risk management. They're an aspect of compliance. If you've got a healthy corporate culture, you're probably not going to be breaching the law. Also, the idea that they promote integrity, confidence, and ultimately trust, which is the other big word in the British Academy project. And finally, that they are basically an integral part of economic success, that nobody wants to invest or be a consumer of a company that has a poor corporate culture. So this is why they say it's so important. Now, very rarely is corporate culture defined, however. So everybody talks about it, but they don't tell us what it is. And I didn't want to get into a huge debate in anthropology and sociology about what does corporate culture mean for the purposes of this project. So I adopted the Australian Securities and Investments Commission, our business conduct regulator in Australia, what it says corporate culture means and why it says it's at the forefront of their regulatory approach at the moment. And so ASIC, the business conduct regulator in Australia, said it's a shared set of values or assumptions in a firm, or in shorthand, it's the mindset of the firm. And you'll also see a lot of references to corporate culture being the organisational DNA, or the collective corporate conscience. So all these things come up in terms of talking about what it is. So how I became interested in thinking about corporate culture was in quite a narrow range of circumstances. It was when the Wells Fargo scandal hit. And for those of you that don't know about that scandal, big banking scandal in America, one of the largest banks in America, and the scandal involved low-level employees in the bank who were given certain targets to reach as part of, their performance review, and they were quite difficult to reach those targets honestly, and so there was widespread dishonesty in the bank where they basically created false accounts and fake customer accounts. So in late 2016, I wrote just a short opinion piece for the Oxford Business Law blog, and it had what I hoped was an intriguing title. It was called "What Do Colonialism and Pizza Delivery Policies Have to Do with the Wells Fargo Scandal?" And I ended up thinking that both these matters had quite a lot to do with the Wells Fargo scandal, and I'll explain to you why I thought that. So I was looking at the sorts of incentives that can drive people within organisations, and they can be good or bad. And so I think colonialism, an example of incentives where the managers went out and did exactly what those incentives were meant to make them do. A good example is given by the Scottish historian Niall Ferguson in his book Empire, because he makes the interesting point that the Dutch East India Company had a very different remuneration policy to their English counterparts, and it created different incentives. So Niall Ferguson says that the Dutch, when they were sending out their managers to go and colonise the New Worlds, they basically remunerated them on the basis of gross revenue, not net revenue, which was how the English remunerated. And that had certain consequences. It meant that the Dutch went out and colonised a much broader area than the British. So the British would colonise, the British are here in the Lemon, they would colonise smaller areas that were extremely wealthy and valuable, whereas the Dutch just said, well, we're getting gross revenue, so we'll go far afield as possible. So I saw that as a sort of incentives that got the results that the Dutch wanted. I assume it did get them the results they wanted, but perhaps it didn't. But I'm assuming it's a good incentive story. My bad incentive story relates to Domino's Pizza, because in the 1970s, Domino's Pizza brought in what they thought was this genius marketing ploy, which was to say 30 minutes delivery door to door, or your pizza is free. And of course, everybody that had ordered a pizza was basically crossing their fingers that the pizza would arrive at, 32 minutes after they'd made the phone call. The drivers who were delivering the pizzas had all undergone driving training. You must drive safely, ethics training, you must be ethical. But the pressure that was put on them to make sure that the company didn't suffer the loss of the pizzas being free was such they just forgot all those good driving training lessons. And so pizza drivers from Domino's were involved in many accidents where they were running over pedestrians, they were going through red lights, doing anything to deliver within the 30-minute period because they were frightened they would lose their jobs if they missed the 30-minute period too often. So that policy was in place right up until the mid-1990s when a court in St. Louis basically awarded a woman $78 million in mainly punitive damages after she had been run over by a Domino's pizza driver. Now, the Domino's pizza example of perverse incentives and the externalities that can be visited, it's a story about low-level employees being afraid to lose their jobs. But of course, remuneration bonuses can act in exactly the same way. They also can have perverse incentives. And I always like this quote from Kurt Eichenwald after the Enron scandal, because Kurt Eichenwald said the levels of compensation at Enron were such that they'd be a powerful incentive for anyone to do anything. It was just lucky they stopped where they did because they were so huge, the bonuses, that anyone could do anything. Now, that was then, but it's still very important now in Australia with the Royal Banking Commission, because in that interim report, the Commissioner Hayne, he said that the culture and conduct of the banks, which had resulted in very poor customer services, charging people for no service, charging dead people for no service, he said it was all driven by remuneration practices and policies. And he said it was a simple but telling observation that whenever there was any wrongdoing that he was examining, that the person who did it or the entity or both benefited financially from it. And so he said, nobody committed wrongdoing and then didn't benefit. So the Wells Fargo banking scandal, I think, really shows a number of those aspects of, I guess, both the colonialism story and the pizza delivery story. Wells Fargo had a very aggressive growth strategy, like the Dutch East India Company, but also it had that essence of the Domino's pizza story, where Senator Elizabeth Warren said that those low-level Wells Fargo employees were squeezed to breaking point. They were told by the CEO, he would make public statements saying 8 is great. And what did that mean? It meant you should get every one of your customers to have at least 8 bank accounts with us. Now, I don't know about you, but I don't have 8 bank accounts, nor would I wish to have 8 bank accounts. But that was basically this policy that was being pushed from senior management. Now, Wells Fargo said, we just had a few bad apples. A sociologist called Susan Silby, she has written about bad apples versus, or rotting apples versus rotten barrels. And, there were a lot of rotten apples at Wells Fargo because the number of unauthorised or fake accounts that were started up by the bank was 3.5 million. That's a heck of a lot of fake accounts for people who apparently were not communicating with one another, were just thinking this is the only way we can reach these targets. Also, they had a lot of bad apples. So 5,300 bad apples were sacked at Wells Fargo. Many of those were whistleblowers who, the second they blew the whistle, they were shown the door. So Wells Fargo said that's not who we are, but there were many indications that it was just who they were. So once I started looking at Wells Fargo through this corporate culture lens, of course you see it everywhere. And so I started looking at all these other very recent scandals and seeing similarities and differences in the way that they played out, that the wrongdoing was quite widespread, less so in the sexual harassment cases, but generally quite widespread, and that it was coming from certain incentives that were being sent down, usually from senior management. So just in looking at these, the similarities, you know, the bad apples argument was used again and again. The VW emissions fraud, initially VW said, oh no, this is just a couple of rogue software engineers. We know nothing about this. Stakeholder harm. So Wells Fargo caused its customers great harm because they were paying for these fake accounts. Stakeholder harm for a range of different stakeholders. So, of course, employees in the sexual harassment cases, and then sometimes incredible harm to the environment and to the community. So the emissions fraud, you know, they haven't worked out how many people that would have killed, but basically it was letting out very toxic into the environment. The BP Deepwater Horizon oil spill, terrible environmental consequences. Some of the scandals, it was very easy to find who was the employee who had committed the wrongdoing. But in other cases, particularly those involving technology, it was much more difficult to actually identify who would be the person at fault. And so I think that's the case with BP particularly, and the Commonwealth Bank of Australia scandal. This one involved putting in place these apparently intelligent deposit machines in 2017, which then allowed you just to deposit huge quantities of cash. And so a few years later, they suddenly find out that $8.9 billion has been deposited in cash, which is basically involving money laundering and, terrorism, breaching anti-terrorism rules. So not great. And this APRA, Australian Prudential Regulation Authority, brought out a report earlier this year, and it said the fact that this Australian bank, which is an icon, was performing so well for so long and the whole way through the global financial crisis, the APRA report said it dulled the organisation's senses to the non-financial risks because it was a financial titan and it just simply did not see the non-financial risks. As I said, in most of these cases, the wrongful conduct was committed quite low down in the organisation, and that is a very typical way. If you look at corporate criminal literature, that's a very typical way in which corporate crime is committed. It's committed by low-level employees who are feeling pressure from above, while the people above say they don't know anything about it. So, my question to you, the students, is who should be responsible when there is this kind of widespread wrongdoing in organisations? And so in my chapter for this book, I'm looking at a number of possibilities. Firstly, I look at the possibility of criminal liability for the entity itself, and in doing that I look at corporate theory, the fact that in the 19th century corporations were viewed as a persona ficta, that they were not real, and therefore the only real people were the individuals that comprised them. So at that point in time, there was no entity liability, no corporate criminal liability. Some countries still adopt that. So I don't know if there's anyone from Germany here, but Germany still has that concept, and much of continental Europe adopted that. In recent times, however, US, UK and Australia, which are the three comparative jurisdictions I look at in this project, they all do have corporate or entity liability, criminal liability, but the contours of it are very different in each jurisdiction. It's much, much easier to make it out in the United States because the US simply adopts vicarious liability and says if any employee has done an act in the course of their employment, which is a criminal act, then the corporation is criminally liable for it. And that is why in the last 30 or so years there's been controversy because prosecutors in the Department of Justice in the US, they just go after the corporation. And the corporation folds immediately. These cases do not go to court. They do a deal with the Department of justice, and corporate culture just comes in terms of whether it's an aggravating or a mitigating factor. And after the global financial crisis, there were a lot of people in the US that were very critical of that, such as Justice Jed Rakoff. And he went back to the 19th century and said, corporations don't commit these crimes, people do. Go after the people. And he wanted to go after the senior managers and directors of companies for criminal liability. So too did Senator Elizabeth Warren. She absolutely grills in a Senate hearing the CEO, John Stumpf of Wells Fargo, and she says, until people like you, Mr. Stumpf, are in jail, rotting in jail, we will have no accountability in this country. So that's who she wants to go to jail, and it's who Justice Rakoff wants. But then, of course, there's the individuals that are often committing it. And then there's this other possibility here of not sending directors and officers to jail, but rather bringing civil proceedings for breach of directors' duties against them. So can I just ask the students, I mean, in this kind of scenario, where would you want, you know, the first action to be? Have you got any views? Do you want to sue everybody for everything, or do you think some of these sort of actions would make more sense than others? Anybody want to say anything? Yeah.
Maybe you could go like both ways to look for like money within the companies, and then criminal offences within the individuals.
So you want to get compensation out of the company?
Yes.
And is that a good idea? Does anybody think that might be not a good idea? Yeah.
I don't think that would be fair, because those costs are ultimately passed on to shareholders who really had to lose.
That's the argument, you know, why people like Jed Rakoff say this is not good, how the DOJ is prosecuting corporations, because they might then disgorge $1 billion, but who's going to be harmed? The shareholders, and also potentially employees if the company then is so destabilised that it has to sack people. So it can be a valuable tool. I know Professor Sam Buell, who's a corporate criminal lawyer from Duke University and was one of the prosecutors in the Enron case, he says that by suing the corporation for criminal liability, it sends a message that the senior managers are not doing a good job. That even if you're not bringing proceedings against those people, it's harming their reputation. So he thinks, like you, that it can be valuable. What about these people, the individuals? So in the Australian banking scandals that are in the Royal Commission at the moment, they're all kind of low-level, mid-level financial advisors that have been ripping off their customers. Should we be suing them, or in the Wells Fargo, those bank employees? Yeah.
Should we not be seeing if there should have been checks and balances in place, that senior people should have been supervising, or there should have been some form of like check that could have prevented a lower level employee committing it in the first place?
Right. Okay. Yeah. Yeah.
I was about to say, I think the directors and senior executives are responsible for the strategic direction of the company, and there seems to be a lot of sense to the Yates memo, which says the DOJ should prosecute, effectively get into the C-suite, because the only way you change corporate culture or corporate decision making is when the directors around the table think they could be sitting in prison as a result of their decisions.
Right. An Aussie accent. Is it Aussie?
I was taught by you.
Oh, okay. Hi. So, yes, and thank you for bringing up the DOJ, because I was just talking to you about how that 30-year trend for prosecutors in the US to go after the corporation, after Justice Jed Rakoff came out with this criticism of saying corporations don't commit crimes, people do, sorry, what's your name? Aidan or Hayden? Hayden. There was this memo by Sally Q. Yates, and she said, and it was really driven by that criticism, she said, from now on we are not doing any deals with corporations, and often those deals were done without the corporation admitting any wrongdoing. And she said, we're not going to do those deals anymore unless basically the corporation gives up the individuals who were responsible. Now, the assumption is that those will be senior managers and directors. But what is going to be the difficulty of either under criminal law or even potentially under civil law making those people responsible? I guess going to your point of, oh, well, shouldn't they have been putting in checks and balances? Let's look at criminal law first. What's the difficulty there? Anyone? Well, criminal law is real, and Professor Sam Buell makes this point. He says there is this responsibility gap because criminal law really requires mens rea, intentional wrongdoing, and these people are going to say, sitting up the top of the hierarchy, oh, we didn't know this bad stuff was going on. So there is the difficulty of, going after them for criminal liability of did they have the correct mens rea, a guilty mind. And there's also the difficulty that criminal law doesn't cope particularly well with omissions. So there are certain examples where you can be criminally liable for an omission, but they tend to be exceptions. So the criminal liability for individuals is more problematic. But in the paper, I end up trying to look at this, which I think goes very much to your point, or both your points, of should the directors and senior officers have been overseeing things so that, this culture couldn't fester and then produce this wrongdoing. So let's have a look. What I do in the paper is and I'm going to scoot through this because then we'll have some time for questions afterwards, but in the paper, what got me thinking about this last category of, are they in breach of their duties, was some work that was done in the 1960s to 1980s by some very famous American corporate law academics. And the first of those was Professor Mel Eisenberg, and he said the role of directors is to oversee and to monitor management. So management, they're running the show in the kitchen, but then the board of directors, and this is where you start to get independent directors having such an important role in modern corporations. Mel Eisenberg said that's their role, to oversee. But then Professor Victor Brudney, also a huge doyen of US corporate law, he said, well, that's all well and good. They're meant to be, overseeing, they're meant to be monitors, but what are they meant to be monitoring? And he said there's at least three possibilities: organisational integrity, efficiency and performance, or social responsibility. And I would say that from the 1990s, from the finance law and economics theory of the corporation, the dominant theory of what directors are meant to be monitoring is the second one. Today, I think institutional investors do a lot of that monitoring to make sure that the company is not throwing money at the wind. And so that leaves, well, to what extent do directors have to monitor integrity and social responsibility? And I think the organisational integrity is inherent in this corporate culture debate. So in the paper, I look at, if we do think that there is potential for civil liability for breach of directors' duties, how does it differ across the US, UK and Australia? So here is a Cook's tour of those three jurisdictions, and as you'll see, I come to the conclusion that Australia has much more likelihood than the other jurisdictions of actually being able to pin liability for failure to monitor integrity onto directors. But let's start with the US. So US, famous, it tends to be called the duty of oversight in the US, famous case from the mid-1960s, which says we don't expect directors to be, going down into the depths of the company seeking out wrongdoing. They don't have to be the FBI. They don't have to assume bad stuff is happening. All they have to do is, if they are hit in the face with bad stuff, they need to respond to it. That stayed on the books till 1996 with this case, Emery Caremark. And although in the dicta, initially in that case, the judge says, oh, no, things have changed, directors really do have to oversee what's going on in the company, nonetheless, in the end, he says, but unless the directors are actually acting in bad faith, have an utter failure or intentional dereliction of duty. Well, I'm yet to meet a director who says, oh yes, I was intentionally derelict in my duty. They just don't say it very often. That is the only instance where it will fall under the duty of loyalty in the US and won't get the protection of either the business judgment rule or exoneration clauses or exculpation clauses in the Charter. So, although there are these fine aspirational statements in Caremark, the hard law from it is directors have very little to fear. And that's come out in a lot of these cases between 2006 and 2016. In all of them, they say this high level that's required of bad faith, utter failure, intentional dereliction has not been met. Okay, no liability. Two possible tripwires, and the first of these, I'm immensely grateful to Mark for bringing this case to my attention. The majority judgment in this case, City of Birmingham retirement, is exactly as we would expect from what I've just said. The majority judges say, oh, these directors of a North Carolina company that just spewed toxic stuff into a river in North Carolina, they didn't do that intentionally, so therefore they could not possibly be in breach of their duties. However, Chief Justice of the Delaware Supreme Court, Chief Justice Leo Strine, who, is usually pretty friendly to management, he comes out in dissent, and I think it's really, really interesting to hear. He thought the directors would not be protected because the company's whole strategy was to skirt the law and to, skate on thin ice and to, just ignore the law wherever they could get away with it. And these were very important environmental laws, and they consciously did that, conducted a strategy. So that's one possible, tripwire for the future. It might be a harbinger of things potentially changing in relation to CSR oversight and integrity oversight. And the other is this federal law case where two academics in the US, Hilary Sale and Don Langevort, have said at federal law, directors can be liable even though they didn't intentionally make misstatements. So these are both potential ways in which they might be liable. Overall message to US directors, don't worry, you have nothing to fear, apart from those two tripwires. But that's not necessarily good from a policy basis because it doesn't really give them incentives to care about monitoring. And that's the point that Holger Speyman makes in that article. Okay, bringing Coles to Newcastle, bringing English law to English lawyers and English students studying in England. In the UK, you would think that there was much more potential for liability in these corporate culture type of wrongdoing cases. Oversight liability goes back as far as 1925 in relation to the duty of care with City Equitable. Lots of people complained that was too low a benchmark. It was sort of a gross negligence benchmark, but it was still potentially liable for failing to oversee. That standard got ratcheted up in the mid-1990s in a series of cases that said there is this heightened objective standard. And then, interestingly enough, there's this Secretary of State for Trade and Industry against Baker, which said directors have to monitor not only for competence of those below them, but also from an integrity perspective. And that, of course, goes back to Professor Victor Brudney's ambiguity of what are we monitoring for. But the reality in the UK is that nobody's suing for this. There are very, very few cases. And the reason is generally perceived to be largely procedural. The fact that the UK has a private enforcement model and shareholders very rarely bring derivative suits for this kind of matter, partly because the UK, in contrast to the US, has a loser pays model of litigation. And that really focuses the mind, the fact that if you bring the action and you lose, you're going to be paying both sides legal fees. It makes you think twice about bringing the action. Also, In the UK, as opposed to the US, there are no class actions. I mean, we have class actions now in Australia. We've had them since the 1990s, but I don't think you still don't have them in the UK, do you?
We have a group litigation order, which we say is a class action.
Do you? Yeah.
We have amalgamated claims, but we don't have common fund class actions.
Right, yeah.
So attorneys don't have, solicitors don't have anything near the incentives that US attorneys have got to bring class action.
Yeah. So again, not the incentives there under in the UK that you have in the US. And also, a lot of the directors' duties cases in the US come up in the takeover context. And in the takeover context in the UK, they're not in the courts generally. They're in the takeovers panel, so they've been hived out. So, yeah, not much on, the possibility of that kind of liability for failure to monitor integrity or social responsibility. There is this new senior managers and certification regime, which does try to get accountability of more senior people. Too soon to tell how that's going to work. I have no idea how stringent that might be. And of course, we've got lots of references to corporate culture and what directors should be doing in relation to creating a healthy culture in this new 2018 draft of the UK Corporate Governance Code, but that's aspirational, pretty much. So, Australia, very quickly. We have had the concept of corporate culture potentially as a very important matter in Australia since the mid-1990s, when this Criminal Code Act was passed. Now, that Criminal Code Act was not passed anything for what we're talking about now with director and officer liability. It was passed in relation to entity liability, what I talked about before. When can a corporation be criminally liable? And historically, Australia adopted the UK model of Tesco, which is a corporation can only be criminally liable if the people at the very top, the board or the senior managers, knew about the wrongful action and basically were responsible for it. Otherwise, the company would not be liable. This Criminal Code Act greatly expanded the circumstances in which Australian corporations could be criminally liable at a theoretical level. And they focused on, was the organisation as a legal person blameworthy for what happened? Did the corporation authorise the wrongdoing? Well, how do you authorise it if you're a corporation, if you're a legal person? Well, the Act said, did the corporation expressly, tacitly or impliedly authorise the commission of the offence, and said one of the ways in which it could do that was if the corporation had a corporate culture that encouraged, i.e. had incentives to do the wrongful act, or tolerated, like in the sexual harassment cases. After the improper conduct occurred, the corporation let people get away with it. That if that was what was going on, then the corporation itself could be criminally liable. Now, I thought when this provision was brought in entity liability, I think it didn't start until 2001, but I thought it was going to be a game changer in terms of putting pressure on senior managers and directors to make sure that they didn't have perverse incentives that could encourage wrongdoing. And I was completely wrong in my prediction because basically what happened was that all the important statutory provisions that could pin criminal liability on a corporation immediately put in a provision excluding the operation of this Criminal Code Act. So there was nothing really relating to corporations that it could attach to. And so it languished and, it was just this weird, hangover of an earlier era that had no work to do. It was never considered by the courts. And then it kind of resuscitated in 2015 when the then head of the Australian Securities and Investments Commission, Greg Medcraft, said, we've just found that we've got this provision in the Criminal Code Act. Wow, we love it. We are going to extend it to all these financial market offences, and not only that, we're going to make it apply to senior managers and directors who oversee companies that have got flawed corporate culture, and we're going to put them in jail. So he was doing exactly what Elizabeth Warren wanted to do with John Stumpf. And of course, there was a volcanic eruption in the Australian business community, and it never happened. But what I think is going to happen in Australia is I think that our directors' duties can catch this kind of conduct. And so I've got a couple of examples up there, going back to Professor Brudney's, what are they meant to be monitoring? One of my oldest friends from law school, who's a very senior barrister, Noel Hutley, he wrote a piece in 2016 with his colleague, Hartford David, and he said directors of companies that fail to take into account climate change risks can be in breach of their duty of care and diligence. And then we've got a series of these so-called stepping stone liability cases. And they say that if the company commits a wrong that results in a fine or harm to its reputation, that the directors can then, as a secondary matter, be liable for allowing the company to do that. Why doesn't Australia fall into the same trap as the UK if nobody brings the legal action? Well, the answer to that is Australia, for its statutory directors' duties, has a public enforcement model. And under that, it is ASIC that brings the action, the actual business regulator. And ASIC brings these actions all the time. So I think we're going to see more of them, and I think there's going to be more interesting stuff coming out in the Australian Banking Commission review. So I'm finished. I'm done, Mark. You guys can ask questions if you want to.
Thank you, Chair.